Good morning. An important judgment which will facilitate you how to file cases if you are defending insurance company, how to defend, how you should be very vigilant. If despite your statutory claims, if you fail to raise these objections in pleadings before the tribunal or at least on appeal, then when courts are not inclined to help the insurance company. That one thing. Another thing is, what all are the governing principles, statutory rules, tariff rules, wherein the insurance should be booked with correct particulars. This is the case wherein claim under section 147, 149 was filed. The problem was, this is AIR 2025 Supreme Court 3446. AIR 2025 Supreme Court 3446. Manju Shah and others versus United India Insurance Company Limited. What happened? The owner of the vehicle's brother was driving the vehicle, and the vehicle resulted in accident, and driver died. So he claimed compensation, and the tribunal granted compensation 25 lakhs 82,000. Then when they went to High Court on appeal, division bench appeal, the High Court has held that there is no statutory liability because the insurance was third-party insurance. Apart from that, there was some personal insurance also, that is contractual liability. So that is only 2 lakhs. That 2 lakhs was only awarded. This 25 lakhs 82,000 plus was rejected. Then the matter went to Supreme Court. The Supreme Court has categorically held that you have not pleaded before the tribunal. You have not pleaded before the High Court on appeal. But High Court has voluntarily setting aside the order. This is what they say. They say it is not the statutory liability but the contractual liability of a personal action cover which forms the basis for claim raised. Admittedly, there was a personal accident cover taken. The question is only as to whether liability was limited or not. As we notice, this is important. Neither the insurance policy before us, nor do we see any contention of limited liability having been taken from the order of the tribunal, which notices contention taken in the written statement. The written statement, as we observed, has not been produced in the records of the case. Even in the memorandum of appeal, the insurance company which produced Annexure 2, we do not see any such ground for limited liability having been taken. So this is one thing. The another thing is, most important thing is, this is the IMT, Indian Motor Tarif, which was guided by Tariff Advisory Committee. The Tariff Advisory Committee time to time issues guidelines which is binding the entire India. They say the IMT, Indian Motor Tariff, is binding on all general insurance companies operating in the country and ensures uniformity and fairness in underwriting motor insurance risk. That is most important. IMT 16 tariff thus says personal action to unnamed passenger other than the insurer and paid driver and the cleaner. So all these things you have to. Then they say capital sum insured, that has to be stated for every person, the per capita income to be claimed. All these things are there. Therefore, they set aside the Honorable High Court order and restore the tribunal order only because there was a faulty defense by the insurance company. So, kindly go through this judgment, keep it in file so that you have to thoroughly go through these tariff rules, so many other words being used. What is statutory liability? What is contractual liability for the insurance? So many things are there. Best wishes.